have 12 of your peers if you want to. Say, you know what? I'm not guilty, and they have to prove it. Bring 12 people in of the community to find me guilty, and you have to put on your case. I don't have to say anything. So that's what they're saying right there. The beginning of a criminal trial. The wheels of justice are put into motion when a person has committed a crime. The person who commits a crime may be arrested and then arraigned, after which a preliminary examination may result in holding the person over in court, and or grand jury may investigate facts surrounding the accusations. Yeah, so that's the beginning of the trial. They have to, bring him before a grand jury to find out if there's even enough evidence to bring him to trial. Grand jury investigation. As noted previously, a grand jury is selected from the citizens of the community. So, people just come in and they just hear these cases. And it's like they said, up to, was it 24? 24 people on the grand jury? 23? The grand jury members consider all business brought before them by an elected public officer who may be called the prosecutor, the prosecuting attorney, or the state's attorney. And those are all done ex parte. So the state's attorney comes in, presents this case to the grand jury, and that's all they have to prove. The defense doesn't get to come in and prove anything. They just come in and say, hey man, this guy did this, this, and this, and we think we have enough evidence to prove it. And they get to determine whether it is or not. The grand jury is then instructed as to the law and their duties and responsibility by the judge. This jury charge or instruction by the jury is given at the beginning of the investigation rather than at the end. The court reporter normally reports his charge, but it's not usually transcribed. And it just kind of goes on to tell, stuff that we've kind of gone over. The indictment, once the indictment is a formal means of charging a defendant with a crime after the investigation by a grand jury. So once the defendant finds there is sufficient evidence to bring this guy to trial, then that's what's called the indictment. Okay? Another name for the indictment is called a true bill. So it's the same thing. Preliminary examination. A justice of the peace, judge, or magistrate presides over the preliminary examination. This is a hearing held to decide whether sufficient evidence exists to order an accused person to be held over for trial in a higher court within the jurisdiction. If sufficient evidence is presented by the prosecution or in a preliminary hearing to indicate a probable cause to believe that the person who is the subject of the hearing committed the alleged crime, he or she is bound over to face the trial. I don't know if you guys have ever seen that movie, My Cousin Vinny. Have y'all ever seen it?
Yes.
They had a preliminary hearing, and Joe Pesci never asked any questions. So, on the way back to the prison or whatever, the guy was like, you knew you could ask questions, right? And he's like, well, you're in Alabama, there's no way that this case is not going to trial. But what they did was they brought in witnesses and asked these witnesses what they saw, blah, blah, blah. And, that was enough evidence, before the judge to say, you know what, there is enough evidence to have this. We are going to have a trial. The coroner's inquest. Reporters may also be called on to report other investigatory hearings that will result in the formal charging of a defendant in a crime. A coroner's inquest is called to determine the cause of death whenever foul play is suspected in the death of a person. In some states, the inquest is automatic when a person dies for no apparent reason. So really, what we call it here is an autopsy. They perform an autopsy or a coroner's inquest, and, they find out, well, you know what? This guy didn't die of natural causes. This guy was beaten to death. It doesn't really show, but on the inside he had, bruises and bleeding and blah, blah, blah. And, so that's what a coroner's inquest is. The arraignment and other pretrial matters. An arraignment is a hearing in which a person is accused of a crime and is brought before the court to enter a plea to charges contained in the counts in the indictment. We've already kind of gone over that too, over the arraignment and what, so they come in, the grand jury charges this guy, and he gets to come in and say, you know what, I didn't do it. And, he gets to enter a plea of, guilty, not guilty, or nolo contendere. And that's what they're talking about right there. Sentences are reported verbatim, making sure that different sentences for different counts are recorded properly. Record whether a sentence is observed concurrent or consecutively with other charges. Concurrent sentences are served at the same time, whereas consecutive sentences are served one after another. So do y'all know what that means? A guy may have killed 3 people, and he's serving 3 life sentences, but they're concurrent. So he's just going to serve the 1 life sentence.
Because he's only got 1 life.
Yeah. But, if he serves consecutive sentences, then he's going to serve 3 life sentences. And I don't know if y'all heard about the one, and I think it was the guy, I think it was the movie theater guy that just got convicted or whatever, and they charged him with 17 life sentences or something like that. It was crazy. I don't remember exactly what. And then an extra 170 days. Or it was something crazy. I can't exactly.
Like life sentences plus like so
Yeah.
many extra days, like
Yeah.
okay.
So he's going to serve, 17 life sentences plus 180 days.
That means he's dying.
Yeah, so that's really, I don't know why they did that. I wanted to do some research on it or whatever, and I just kind of forgot about it. But, it just kind of came to mind when they were talking about concurrent and consecutive. So, if the defendant pleads not guilty, a trial date is set, and the prisoner is either kept in jail, released on bail, or released on personal recognizance. To be released on bail, the defendant must raise money to provide. You don't know that. Usually I think it's 10% of whatever your bail is. So it sounds like a ton. It's like this guy was put on $50,000 bail. $50,000. So he had to come up with $50,000. He had to come up with $5,000. It's usually 10%, I think. To be released on one's own recognizance is to be released with the assurance that he or she will return to stand trial. Sometimes in the case of a minor defendant, a person may be released in the custody of another person, a parent, or a guardian. So a lot of times juveniles are released to their parents on their own recognizance. It's just a promise that you're going to come back to stand trial. Selection of the jury. Every person has a right to a trial by jury. In civil matters, that right may be waived, and in criminal cases, the defendant may waive his or her right only in some states. Some states require that all defendants in felony prosecutions be tried before a jury. The first step in a jury trial is the selection of the individual who will make up the jury. Usually the process begins with a panel of jurors who convene in the court in which the case is to be tried. Prospective jurors are selected according to statutory and constitutional provisions within each jurisdiction. So, it's, like in the criminal case that I was in, there was 75 of us that went in. There's only going to be 12 people. But, they started asking all kinds of questions like, do you think you can find this guy guilty of 99 years? Some people raise their hand. No. It just seems like way too much. Well, that's what the law allowed, from 5 to 99 years. And they said, do some of you think that drugs should be legal? Some people raise their hand, yeah. Not all drugs. Marijuana, yeah. Cocaine, no. Heroin, no. Just marijuana. Because some people believe that it's for medicinal purposes, and that it's medicinal. Some people don't. They think that it's illegal and it should stay illegal. It shouldn't be legal. So they didn't want those people on the jury because it was a drug case. So Attorneys will examine the prospective jurors as to their qualifications, lack of prejudice, and general knowledge and understanding, which is called voir dire examination. Voir dire is a French term that means to speak the truth. The attorney may challenge or excuse a prospective juror members either for cause or preemptorily, that is, without cause. Depending on the matter, the 12 persons who are accepted as satisfactory on both sides continue for the jury. So they get so many preemptory strikes. Like in mine, I don't remember if it was 3 or 5, but they can just strike somebody and they don't have to give a reason why at all. They just say, you know what, we don't like her. We didn't like him, you know, because of something that he said or, you know, religious belief or, you know, whatever. And they don't have to give a reason. They just say, you know, or they can strike them for cause and say, you know what, Judge, we don't want this guy. I mean, this guy thinks that all drugs should be legal, you know, or he thinks that this guy is guilty. And they asked us that question. They said, do you think that you could stand to hear the case and be unbiased and not find him guilty? And one guy raised his hand. He said, no. He said, I work at one of the jails or whatever, and I don't think I could. You know, working around criminals every day, I just think if you're charged with something, then you're guilty. You don't want that guy on the jury. So they struck him for cause. So, I mean, there's different reasons for getting struck. So in some jurisdictions, court reporters must report everything that occurs during the voir dire examination. You also have to take everything down, you know, during jury selection, you know, so just in case it goes up and it's like, you know what, I mean, this guy should have been struck for cause, and the judge didn't strike him for cause and he got on the jury. So we're gonna appeal on that. If the matter is a felony case, a reporter will usually be requested to take down the voir dire examination, which must be completely accurate. After a verdict is reached, counsel on either side has the right to subpoena the entire jury and have them returned to court. At this time, questions are asked about what happened in the jury room. So, you know, you're not really supposed to discuss the case during the trial. You know, you're supposed to wait till afterwards or whatever, and if you do, then they can call you back and ask, you know, hey, were you guys talking about the trial and, you know, what was going on? You're not supposed to do that. Before the attorneys begin questioning the veneerman, the prospective members of the jury, they often make a few introductory remarks. These remarks are called opening statements. So to begin the trial, they start with an opening statement and they tell you what they think that they're going to prove in the case. And that's all it is. That's what an opening statement is. Sometimes the entire jury panel is seated in the courtroom and questions are asked of the whole group with responses from one or few prospective jurors to be given. In this case, a reporter often has no way of identifying the particular jurors unless the attorney calls by name and the reporter knows them. So, you know, they'll kind of give like a general overview, you know, well, who thinks that, you know, drugs should be legal, and okay, juror 1, juror 8, juror 12, and then they, you know, they're writing them down or whatever, and then they can go back and individually ask these jurors, well, why do you think that it should, and blah, blah, blah. And the court reporter's taking this all down. So they're going to say, you know, prospective juror number 3, you know, you said that, you know, all drugs should be legal. Why do you believe that? Well, I just do. You know, I think everybody has the right to do whatever they want. If they want to do drugs, then they have the right to do it. Generally, as jurors are called to the box to be examined, the clerk will read his or her name and address. Usually before interrogation begins, the first 18 chairs are filled. If a juror is excused, he or she will leave the box, and a new juror will be called forward to take their place. Yeah. The attorneys on either side can excuse prospective jurors. Jurors are excused by the exercise of peremptory challenges, and that's what I was talking about earlier. You know, they don't have to give a reason. They can just say, you know what, I just strike that guy. That's what I want to use it as one of my challenges. And then you can challenge them for cause. Well, he said, you know what, he can't be unbiased or whatever. He works at the prison and he thinks that everybody who's brought to trial with charges is guilty. And they strike him for cause. Another type of challenge occurs when an attorney makes an objection to the entire panel of prospective jurors. This challenge is called the challenge to the array and asks that the entire panel be excused and that a new panel who more closely represent a group of his peers are selected. So, I mean, you know, say in the opening statement, they say, well, you know, this guy was, you know, found guilty. Oh, man, he wasn't found guilty. He was found guilty by the grand jury. You know what? The defense, you know, may think, you know what, this panel has already been tainted. So, you know what, we want 75 new people to come in and, you know, because we think that these guys have already been tainted, so we want a whole new panel to come in. So that's what that is. At times, a jury may be sequestered or secluded in hotel rooms overnight. These are big trials, guys. I mean, that they don't want you to be tainted by anything, you know, either at home, on the news, or whatever, so they sequester you to stay in. I mean, I think, you know, everybody knows the OJ trial. Those guys were sequestered. They had to stay in the jury, they had to stay in a hotel. They were led from the hotel over there, and they stayed there the whole time, even on the weekends. You know, so you stayed there the whole time. So that's what sequestered means, is to be held, is to isolate or to segregate from the public so that you're not tainted on hearing some of the stuff. Guys, I think it's already kind of late. We had a few more things to go to. It's probably going to take a little bit more time. I don't want to go through it too quick, so we'll pick up with the trial. Okay. Does anybody have any questions of what we went through tonight? We're going to have to kind of pick up the pace next time. I kind of covered some stuff in the beginning. I just thought it was important, a little more important in that first kind of chapter. So, and I don't want to not go over things or whatever. So I want to be able to cover it, what I think is really important. Okay.
Yes.
Anybody have any questions over what we went over tonight? Okay. All right. Well, for next week, if you already read them, 7, 8, 9, and 10 chapters. And I think I told the student to let before 7 through 11. But I mean, if you can, read 7 through 11. If we can get through 11, then we may. So we'll just kind of have to see how it goes. Okay?
You said 8 through 11.
Well, we're still on 6, so we didn't even get to
Oh.
cover 7. It was supposed to be 4 through 7.
Oh, okay, I read
you know.
Typically seven's like 3 pages.
Yeah, it's like, I think it's 2,
So
isn't
it-
it?
Pages, yeah. Seven's very short.
Yeah. Okay? We'll see y'all next week, guys.